Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part of our news session. On 24th of August 2023, an article in The Guardian reported ministers have announced an independent inquiry into the circumstances and handling of the Andrew Malkinson case after he was exonerated last month over a rape for which he wrongly spent 17 years in prison. Kate Maynard, a solicitor at Ekman and Rose, who is representing him in his claim for compensation, said, while we'll welcome the announcement of an independent inquiry into the failings in Andy's case, we regret that it is not a full public inquiry held under the Inquiries Act 2005. Only an inquiry held under statute can compel witnesses and disclosure. The Ministry of Justice said it had carefully considered the issue and decided a non-statutory inquiry was the most appropriate option, building on the approach taken in other individual cases. We, as Spoken Injustice, enthusiastically welcome this decision. But what is a public inquiry? Let's find out and follow us until the end to find out the difference between a statutory and a non-statutory inquiry. But before embarking into this subject, please leave a like if you're finding this video useful and consider subscribing so that we can continue bringing to you the latest news surrounding our criminal justice system. Also, hit the bell button to be notified when our next video is out. We post videos weekly. Thank you. Public inquiries are not to be confused with parliamentary inquiries, which are carried out by a parliamentary committee, either on its own initiative or at the behest of one or both houses. A public inquiry is government-led and is formal and independent investigation conducted by a government-appointed individual or panel into specific events, issues, or matters of public concern. Public inquiries are typically established when there is a need to gather evidence, examine the facts, and make recommendations for action on issues of significant public interest, or when there are concerns about transparency and accountability. Public inquiries in the UK have been used to investigate a wide range of issues, including major disasters, public scandals, healthcare concerns, and other matters of national importance. Examples include the Hillsborough Disaster Inquiry, the Iraq Inquiry, also known as Chilcot Inquiry, and the Grenfell Tower Inquiry. The establishment of a public inquiry is a way for the government to address serious issues and provide a mechanism for impartial investigation and public accountability. Public inquiries, though government-led, are independent. This independence is essential to ensure the credibility and impartiality of the inquiry. They are also open to the public and the media, and transcripts or summaries of the proceedings are typically made available to the public to ensure transparency and accountability. Public inquiries are an inquisitorial rather than adversarial process. The inquiry's recommendations are not legally binding. It is up to the government or other relevant bodies to implement any recommendations. Inquiries take an average of 2 years. However, there have been shorter and longer inquiries. According to Wikipedia, the Hammond inquiry into ministerial conduct relating to the Hinduja affair in 2001 has been the shortest inquiry, taking just about 45 days to report its findings. The inquiry into the hyponatremia related deaths in Northern Ireland is the longest, which took 13 years and 3 months to conclude. Let's take a look now at statutory inquiries. Statutory inquiries are initiated by the government by powers under the Inquiries Act 2005. As Section 1 of the Act states, a minister may cause an inquiry to be held under this Act in relation to a case where it appears to him that A, particular events have caused or are capable of causing public concerns, or B, there is public concern that particular events may have occurred. As per the scope of a public inquiry, it is important to note that an inquiry panel is not to rule on or has power to determine any person's civil or criminal liability, as stated in Section 2 of the Act. However, an inquiry panel is not to be inhibited in the discharge of its function by any likelihood or liability being inferred from facts that it determines or recommendations that he makes. The scope is to establish what happened, why it happened, and what lessons can be learned so that it does not happen again. Public statutory inquiries have the authority to compel witnesses to give evidence and produce documents relevant to the investigation. This can involve interviews, public hearing, and the examination of written submissions. Once the inquiry is complete, the appointed individual or panel produces a final report that includes findings of facts, analysis of evidence, and recommendations for action. These recommendations may inform government policy or lead to changes in law or procedure. The findings and recommendations of a public inquiry can have significant implications for policy, governance, and public awareness of the issues at hand. They can lead to accountability measures, changes in regulations, and public debate. Let's now turn to non-statutory inquiries. Examples of non-statutory inquiries are ad hoc public inquiries, committees of privy councillors, and royal commissions. In a report by Graham Cowie, dated the 28th of November 2022 in the House of Commons Library, at page 6, it is stated that many historical public inquiries were non-statutory, such as the Profumo Inquiry in 1963 and the Maze Prison Escape Inquiry in 1983-1984. In the early 21st century, several high-profile inquiries, including the Butler Inquiry and Cheko Inquiry on aspects of the Iraq War, were also non-statutory inquiries. However, since the 2005 Act was passed, non-statutory inquiries have become slightly less common. Two recent exceptions are the Daniel Morgan Independent Panel and the new inquiry into matters related to Sarah Everard's murder. What are the advantages and disadvantages of non-statutory public inquiries? The Cower report tells us at page 5 that holding a non-statutory public inquiry provides greater flexibility on procedure rules. This can make it easier to hear privately, if necessary, evidence that is sensitive for national security reasons, for example, and in some situations, this can better secure the cooperation and candor of core participants, such as the intelligence services, police, or the military. However, non statutory inquiries cannot compel witnesses A. to give evidence under oath, or B. to produce other evidence relevant to the inquiry's work. There is therefore a greater risk that uncooperative witnesses or co-participants will impede a non-statutory inquiry's progress. Is it possible to convert a non-statutory inquiry into a statutory one? Indeed it is. Section 15 of the Inquiry Act 2005 provides powers to convert a non-statutory inquiry into an inquiry under the Act. Again, the report by Cowie tells us that there are recent examples of non-statutory inquiries or reviews being converted to statutory inquiries in order to strengthen their evidence powers. Independent inquiries into child sexual abuse, the Brooke House inquiry, and the Post Office Horizon inquiries were all product of converted non-statutory inquiries or similar internal investigations. However, it is important to note that subsection 4 of section 15 states that no rights or obligations arise under or by virtue of this act before the date of conversion. I hope you found this video useful, and if so, please leave a like and also leave comments below. Also, consider subscribing if you have not done so already to allow the content of our video to reach a wider audience. And finally, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again next week. We look forward to usher you as we sit and rise in this unique